welcome everyone to the seminar today on voluntary assisted dying in Queensland. So our speakers who I'll talk about in a tick today bring you an incredibly important and timely project. This identifies values and beliefs of relevant stakeholders in the voluntary assisted dying debate and identifies opportunities for law reform and healthcare practice changes. So I'm very excited about the discussion today, which is really timely and topical. So here's Todd. Welcome, Todd. So can everyone, just first I'll just check, can everyone hear me? Just nod. Yep, okay, great. So I'll introduce the three, well, today Jayne will be doing a talk for about 20 minutes and Associate Professor Laurie Grealish, so hopefully that's the right pronunciation, and also Charles Lawson will be involved then in the question and answer at the end. So what I might do is I'll just read out their bios just in case I miss anything important, so bear with me. So Dr. Jayne Hewitt is a registered nurse with many years of critical care experience. Having seen firsthand how law impacts on the practice of healthcare practitioners and the patients they care for, Jayne undertook a Bachelor of Laws and Master of Health Law at Queensland University of Technology. Now, combining her clinical experience and knowledge of the law, Jayne completed her PhD with the Griffith Law School in 2019. Her research explores the intersection of healthcare and law with a focus on end-of-life care and voluntary assisted dying. So welcome, Jayne. We also have Associate Professor Laurie Grealish, who currently holds a joint appointment with the School of Nursing and Midwifery at the Gold Coast Health. She holds a PhD in government from the Canberra University and currently leads a research program in the areas of preventing complications in hospitalised older people, end-of-life care and work-based learning. Laurie was awarded an NHMRC Translating Research into Practice Fellowship in 2016 to implement a delirium prevention program for older hospitalised adults. We're also welcoming Professor Charles Lawson, who studied science and law at ANU. Most of you already know him. He undertook his PhD at ANU's Research School of Biological Sciences in Molecular Biology and Biochemistry. He also completed a Masters of Law from Queensland University of Technology. Before joining the university sector, he worked as a lawyer in private and public sectors, including the Australian Government Solicitor and the Commonwealth Department of Finance and Deregulation. So his research focus is on biology law and public administration law. So as I said, Jayne will speak for about 20 minutes, then all three will be involved in the questions and answer. So when Jayne's speaking, feel free to drop some questions in the chat function. So I'll compile these questions and start the ball rolling once Jayne has finished speaking. We expect to close the seminar sort of a bit before 1 o'clock. So without further ado, please welcome Jayne.
Thanks, Fran. I'm just going to share my screen. Oh, host disabled participant screen sharing. Are you able to let me share my screen? Sorry, Fran, you're still muted.
So something came on my screen then because I think Mel...
Yeah, you should be able to do it now, Jayne. Can you do it?
Okay, thanks, Mel.
Sorry.
No, all good.
There you go.
Oh, or maybe not. Sorry, everybody, just having some minor technical issues here. First of all, I'd like to say thank you, Fran, for that lovely introduction, and I'd also like to thank Mary for inviting us to speak today. And I'd also like to thank Mel for making it happen for us. I'm Jayne Hewitt, and I'm presenting on behalf of Laurie and Charles. And if you just bear with me for 1 second, I'd really like to get my PowerPoint working correctly so that I can undertake the presentation.
Can you just use your arrow keys, Jayne, to change them? Yeah.
I think we're right now. Good-o. So before we get started, I would like to acknowledge the traditional custodians of the land where we're meeting today and pay respect to the elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander people. So today's session is going to start with a very brief history of the voluntary assisted dying and the laws in Australia. We're going to have a look at what's changed and why now, and introduce a theoretical framework for exploring policy change. And we're going to finish off with the all-important question of why does this all matter? It should take about 20 minutes, and then we'll have some time for questions at the end. So before we get started, just a quick note on terminology. In different jurisdictions and at different times, how we describe permitting a person with a terminal illness to voluntarily end their life has been referred to as physician-assisted suicide, physician-assisted dying, voluntary euthanasia, and more recently, medical assistance in dying. In Australia, we've adopted the terminology of voluntary assisted dying, or VAD. And so that's the term that we're going to use to encompass all of those things today. So it was back in 1995 when, in fact, it was the Northern Territory that became the first jurisdiction in the world to legalise voluntary assisted dying. Now, unsurprisingly, that act actually caused a little bit of a furore, not just in Australia, but internationally. It received extensive criticism, but also quite a bit of support from politicians, healthcare practitioners, religious groups, academics, the media, and of course, the general public. Between September 1996 and March 1997, there were 4 people who were assisted to end their lives under the Act, but that was it. In March 1997, the Commonwealth actually passed the Euthanasia Laws Act, and that effectively dismantled the Northern Territory law. Since 1997, though, in Australia there's been more than 50 unsuccessful attempts, or there were more than 50 unsuccessful attempts to enact legislation that would permit those with a terminal illness to choose when and where they die. So we think that the number and frequency of bills that have been proposed suggest that VAD's a practice of importance to the Australian community. Nevertheless, being able to balance the desire for choice about when to end a life with the need to protect vulnerable members of society has proved to be a bit of a challenge. While Australian legislatures have grappled with these challenges, there are some other jurisdictions where they've managed to move forward. So internationally, voluntary assisted dying, or VAD, is legal in certain circumstances in the Netherlands, Belgium and Luxembourg. In the United States, there are now 10 states where VAD is lawful. VAD's also permitted in Canada and Colombia. In Switzerland, and more recently in Germany, assisting a person to self-administer a lethal medication in certain circumstances has also been decriminalised. So where are we now in Australia? Well, in November 2017, after more than 2 years of quite well-directed and structured public consultation, first involving a parliamentary committee inquiry and then a ministerial advisory panel, Victoria became the first Australian state to legalise VAD. Following an 18-month implementation period, the Act came into force on the 19th of June 2019. Over in the West in 2017, a joint House committee in Western Australia was established to inquire into the need for VAD laws in that state. So they also started with a committee, but after that report was published, similar to the process in Victoria, a ministerial expert panel was appointed to provide advice to the government on the development and implementation of VAD in that state. Their Act, the Voluntary Assisted Dying Act, was passed in December last year, and that will commence once it's proclaimed, probably in the middle of next year. In both states, there are strict eligibility criteria to be met before a person can access VAD. So first of all, a person must be an Australian citizen and they must be a resident of the relevant state for at least 12 months. They've got to be over 18 years of age. They must have decision-making capacity in relation to VAD. They've also got to have an incurable condition that's expected to cause them to die within 6 months. That time frame is extended a little bit if the person has a neurodegenerative condition like motor neuron disease, up to 12 months. And finally, the condition that's going to cause them to die must also be causing them suffering that can't be relieved in a manner that they consider is tolerable. So in Victoria, the default method for completing VAD is self-administration. So what that means is that the adult is provided with a locked box containing the lethal medication, and they take it at a time and at a place of their choosing. So since the Act has been in operation, nearly 350 people have been assessed as eligible for VAD, and 124 of these have died from taking the prescribed medication. When the Western Australian laws come into force, the adult can choose whether or not they self-administer the medication or whether they have a health practitioner administer it. So in both of those states, medical practitioners are tasked with assessing whether or not a person is eligible for VAD. And medical practitioners and nursing practitioners can, under certain circumstances, administer the VAD medication. So that makes the connection between these VAD laws and healthcare inextricable. So where are we now in Queensland? Well, back in November 2018, the Legislative Assembly referred an inquiry to the Health Committee, and it asked them to inquire into community and relevant healthcare practitioners' views on the desirability of supporting VAD. So the Health Committee's report was tabled in March this year, and it recommended that the Queensland Government consider a legislative scheme for VAD in Queensland. In response, the government's referred the issue of developing an appropriate scheme and draft legislation to the Queensland Law Reform Commission. So we're not having an expert panel advise the government here. It's the Law Reform Commission that's required to draft the legislation and provide the legislation or the draft legislation and its final report in March next year. So what that means is that next year we will in fact have a draft VAD bill. Whether or not it is introduced into Parliament is still a little bit up in the air. If it is and it does get passed, then obviously the law will need to be implemented. So our research is essentially looking at how a contentious social policy like new VAD laws are implemented. In this project, we're not yet looking at implementation in clinical health care practice. Rather, we're exploring the processes behind getting the laws passed. And to do this, we're going to be using a well-recognised policy implementation framework, which is the Advocacy Coalition framework. So the ACF was created in the late 1980s, and this was in response to a long debate about the strengths and weaknesses of top-down versus bottom-up approaches to policy implementation research. So this framework integrates a little bit of both. In the ACF, policy subsystems are the primary unit of analysis, and these are defined by a policy topic like VAD, territorial scope, and the actors that directly or indirectly influence policy subsystem affairs. Relevant subsystem actors include any person that regularly attempts to influence these subsystem affairs. Now, the ACF sees individuals as being boundedly rational with a limited ability to process stimuli. Rather, they rely on their beliefs as the principal heuristic to simplify, filter, and sometimes distort the stimuli. So the ACF explicitly identifies beliefs as the causal driver for political behaviour and structures them in a hierarchy. It starts off with deep core beliefs. These are the broadest and the most stable. They're predominantly normative values such as the nature of humans or the relative value of freedom or social equality. They're not necessarily policy specific, and that means they can be applicable to multiple policy subsystems. Next up, policy core beliefs. These are a bit more moderate in scope. They can be normative though, so they can reflect value priorities or considerations of whose welfare in the policy subsystem is of most concern. Policy core beliefs can also rely on empirical information such as an overall assessment of the seriousness of a problem, its causes or the preferred solutions for addressing it. And at the bottom of the hierarchy are secondary beliefs. So these are the specific instrumental means that can be used to achieve a desired outcome. Using this framework, policy subsystems are simplified by aggregating actors into one or more coalitions based on their shared beliefs and coordination strategies. So ultimately, the policy process is conceptualised as a political struggle amongst coalitions where policy change reflects the primacy of an advocacy coalition's beliefs. In the ACF, there are 4 pathways that can result in a change in the belief systems of a subsystem or coalition. So the first of these is an external shock. So these are events that are outside the control of the subsystem. They involve, for example, a change in socio-economic conditions, regime change, and extreme events such as some crises and disasters. So it's not hard to imagine that the current COVID crisis, for example, would be considered an external shock. Another time when an external shock resulted in policy change was in the early 1990s when the emergence of AIDS served as an external event that was used by a harm reduction coalition to challenge and change their opponents' pro-abstinence drug policies. So major policy change can also result from internal events. So these occur inside the territorial boundaries or the topic area of the policy subsystem. These are more likely to be affected by subsystem actors. So internal events might include some crises, policy fiascos, scandals and policy failures. Some of the regulatory failures associated with the Bundaberg Hospital scandal and Dr. Jayne Patel back in the early 2000s could have been considered internal events that resulted in policy change. The third way is through policy-oriented learning. This occurs when policy actors consider alternative forms of beliefs that are associated with attaining their goal. These might arise from new problem definitions, policy solutions, or strategies for influencing government decisions. These policy-oriented learnings tend to happen a little bit more incrementally. And the fourth way that we think can be a conceptual pathway to policy change is through negotiated agreements. Now, these usually involve 2 or more coalitions. Negotiated agreements rely on leadership and a commitment of the members to achieve policy change. They tend to focus on empirical issues and trust building. In some cases, negotiated agreements can affect policy change through what's known as a hurting stalemate. This is where warring coalitions perceive the status quo to be unacceptable, but they don't have any access to alternative venues for achieving their objective. So if we're thinking about bad laws, for example, this might occur if advocacy coalitions are faced with statistics about the number of people who attempt or who actually commit suicide because there are no lawful options to support them to end their lives. So using the ACF framework, we're actually going to explore the process of VAD law reform in Queensland. And we recognise that this process might have begun back in the 90s, and we're jumping in just at this point where there's a very real potential for change in Queensland. So the research questions that we're going to try and answer are: what are the deep core beliefs, policy beliefs and secondary beliefs of groups and organisations that had an interest in Queensland VAD policy? Which VAD groups can form advocacy coalitions and can potentially influence VAD policy? And how is it that these advocacy coalitions affect policy change? So to answer the research questions, we're actually going to undertake a content analysis of the submissions that were made by groups or organisations to the recent Health Committee inquiry. And we're going to do that to try and identify the underlying values and beliefs. So between February and April last year, the Health Committee actually received over 4,700 written submissions. Now, we're not going to analyse all of those, but 116 of them were made by groups or organisations. So we're going to access these submissions and undertake some content analysis to identify their deep policy and secondary beliefs, see if we can align groups with similar beliefs to identify possible advocacy coalitions, and to consider whether any of the 4 possible ACF conceptual pathways to policy change is evident. So we think that's all a bit exciting, but the real question is, so what? We're thinking that this research will provide some unique insights into the process of reforming a contentious social policy, and in doing so, it will certainly extend the application of the advocacy coalition framework. But it also aims to bridge the gap between policy implementation, where the implementation object is a policy such as a law or a regulation, and implementation science, where the object is a specific clinical practice, such as a new surgical or dressing technique in healthcare. We need to do this because in healthcare, implementation science has been relied on to support the translation of new interventions and therapies in practice. But in these cases, the evidence they rely on actually comes from scientific and biomedical research. VAD, however, will require the integration of a new healthcare practice, not on the basis of a novel scientific research outcome, but on the passage of a new law. And while we recognise that all healthcare is underpinned by legislative obligations, rarely does the law prescribe how a particular healthcare practice should be undertaken. VAD laws therefore present some unique implementation challenges in healthcare. So to try and address this gap, we're assuming a wider implementation perspective to look for the real-world circumstances and complexities that underpin the policy process. Specifically, we're going to be looking at values and belief systems of stakeholder groups that seek to influence policy change at an emergent stage. Obviously, these stakeholders have a strong interest in seeing their values and beliefs predominate. That's why they've become involved in the policy-making process well before Queensland's first VAD bill has been drafted. I don't think their interest in VAD will necessarily dissipate if and when a bill is passed. VAD will still be a contentious process. So the knowledge our project generates can inform the development of sophisticated and nuanced strategies that will support the implementation of VAD in clinical practice to become a legal end-of-life option. Even if Queensland doesn't end up with a VAD bill, outcomes from this research can still provide a foundation for future comparative policy implementation research. If we don't get a VAD bill, perhaps we can look at what happened differently in Queensland compared to Western Australia and Victoria. So that's the end of my presentation, our presentation. Thanks all for listening. I'm going to stop sharing the screen now.
Thank you, Jayne.